Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
What more do you need to see?
Okay, let's see. This new setup is not quite as easy to use as the old one. All right, we're going to make this work, guys. It's going to work. Good afternoon. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you. Can you give us a party to help the mood? There's a party right there. And Megan, thanks for asking for that. Thank you for the kind words. I need to give you some explanation. And I wish. Let me turn this down just a little bit. Well, actually, we'll fade the music out. How about that? There we go. Let me fade the music all the way out and stop it there. There we go. Now reset it. All right. Let me provide this little update. My wife's sister became pregnant with a little baby that early on in the pregnancy, they thought something was wrong, and they did some tests. And I wish I could tell you, I don't know off the top of my head. I have the worst memory for this, but there was a medical condition where they knew that the child was not going to live very long. They estimate he would probably die before he was a toddler. And as a mom, that is heartbreaking. I mean, how do you both prepare for a birth and a death at the same time? And it's just been very difficult for her, and she just decided to do everything she could to enjoy the little bit of time they get with him. And he had not been born yet. He was, she was still she was expecting, and she got news that the baby had passed, and so. They knew that they were going to lose this child, but wanted to make the child that time together be as good as it could be, and unfortunately they didn't get that time, so that's heartbreaking. At the same time, they have been preparing for this at the same time, so it's not easy. It's that's all in one word right there. SF in Texas. Thank you very much. So thank you for the kind words. Mrs. R.A. is going to be on the phone, talking with her as only Mrs. R.A. can, and helping her. We'll be out there. We'll clearly be out there next week to visit with them, and we might get to be there for the funeral. Depends how things go, what the schedule is. So that's. Anyway, family is wonderful. They're amazing. I shared this morning, I said I used to have a motorcycle, and I sold it to get lawn sprinklers repaired. I actually sold it to her husband, and in return, instead of paying me, he redid our sprinklers back at our old home. And so he's the one that has the motorcycle. But anyway, that's how they connect. I did some, did I flip some switch? I'll flip the switch. There we go. Let's turn things on. Chat is on right there, and we have to say Kim was first in chat with a unintentional message, and I'm not sure. I had to go back and check the rule book, Kim, and in doing that I looked at the rules, and there is a small rule that says that it has to be a message typed into chat. So while you were first in chat with a membership message, which I will show right here, right there. It was not typed into chat. So Kim, I think I have to give the internet to Red Pen this afternoon. with the first typed message in chat. The good news is, Kim, you're off the hook. You can just kick back and relax. You don't have to do any work. And on a day like today, where we've struggled with the internet a little bit, or at least the equipment on my end, that gives you a break. But Kim, thank you very much. Red Pen, this is all on you. We've got you. You need to step up and make this stuff work for us this afternoon, as we'll be jumping back in court here shortly. A Little B, welcome to the jury as well. Thank you very much. Little B also gifted with a super sticker. How's it going? It is going better than I deserve. You guys have been absolutely amazing. I was doing something over lunch which I didn't think I would be doing, and that was shopping for a new switcher and looking at the upgrade to this switcher, which would allow me to connect directly to the Courtroom feed, so I could take this with, and basically it switches from HDMI to SDI, which I think is the right option, and it allows us to tie into some of our other cameras that are like our pan tilt zoom cameras that we'll be using when we're there in court, running the cameras ourselves directly instead of having converters and things like that. And you guys made that all possible. So thank you very much. In the meantime, I've got if I mess up the audio a little bit, no, we've got a solution that will work. It's working. I've got things rerouted. I'm using my other switcher and audio going different directions so that it will work this way, so we can get through until we're basically going to limp through, hopefully seamlessly, until we pull the trigger on that new switcher. So thank you for that. Let's see. Genjo, thank you very much. Some of those wonderful groups that help moms that have a baby that dies just before childbirth or in childbirth, or amazing job they do. Oh my goodness, such good work. Love that. Love them. So. All right, we are about to jump back to court. It's been a little bit crazy this morning. Let me make sure I've got everything lined up. Oh, I don't have my downstream key here. The good news about the upgrade from HDMI to SDI, which basically just means the cable's a different cable, right? Let me show you if I can. How is it they don't have any HDMI cables around here? Okay, here we go. Quick demonstration. HDMI cables look like this. This is the type of cable you'd plug into your TV and your VCR, well, DVD player usually. VCRs I don't think have them, but SDI cables, on the other hand, have a connector like this, which is like a twist locking connector. This is a commercial grade video, and it can run like up to 4K or 8K, I think, on these cables. But they're much more sturdy, and they don't come unplugged. They can't. Most of your home devices, like you can't get a DVD player that has these. This is a commercial fix for that. But so I'd be switching all the HDMI cables, which I have a lot of, for SDI cables, which means I need some more cables. So that's the long and short of it. Little B, thank you very much. We are, yes, thank you. The channel is doing great. Thanks to you guys. It's wonderful. Appreciate all of you. Let's go ahead and bring court up in case they start here any second now. Let me make sure we're up to the second. I'm showing still the wall, but let's see. There we go. We just have the wall. Oh, you guys can see it too. It looks like a BNC. Yeah, it's a BNC twist lock, but that's the name of the connector, and it's actually used for a couple different things. They use that same connector for like antennas for my wireless microphones. The receivers have that same connector, but it's a BNC connector, and then the cable itself, you have to get the right cable so that it will carry the quality of video that you want to carry down at the length you want to run. But the cables run about $1 a foot, so that's not bad. That's doable, because most of the cables I need are very short. Ruth Buck says, all right, I'm a new subscriber, and you've quickly become my favorite YouTube channel. Love from Ontario, Canada. Thank you, Ruth. We have some amazing, wonderful friends up in Canada, friends of the program. So thank you. Thanks for joining us from the cold north, which I know is not cold all the time, but especially right now. You guys have fires. Oh my goodness, you guys have some fires going right now. Please stay safe. Now you have enough to take another vacation, leave us bored. No, I'm taking you with on vacation, Virginia. That's the whole idea. I will be packing this up. Well, once we end Friday night, because I'm leaving Saturday morning. When we end the show Friday night, hopefully we get a little bit of time, because almost everything with me on my desk, almost everything is coming with. Just so I'll be able to run everything I need to from the show from up there. Let's see who this is. We getting a call. It's trying to connect.
Call from.
There we go. Hey, Thal. How are you doing, my friend?
Hey, bud. Pretty good. Dave, did you hear that the French of the Olympics?
Hang on. Whoa, I'm turning you down just for a minute. Okay, keep it really, really clean.
Oh, no, I will. This is very clean.
Okay.
Don't worry, I know the rules. Okay. No, did you hear that the French at the Olympics, they hoisted the flag upside down?
I saw that. The Olympic flag went up upside down. Oops.
But you know what? That's not surprising, because the French aren't used to flying flags that have any color besides white.
I knew there was a joke in there somewhere. I feel bad. You've got so many people worked out, putting together those performances, and getting the flag upside down. It's easy to do with the American flag, believe it or not. I flew the flag for our elementary school. That was like our assignments. And half the time we'd connect it and then trying to figure out, because you connect the two clips, and then the guy running up the pole would pull the wrong end, and it would go around and upside down, and like, no, the other way. So it happens. But thank you, Thal. Appreciate that.
You're welcome, sir.
Need to watch a few more of the competitions. So.
Yep, not a problem. Have a great show. I couldn't resist the joke.
I knew it was in there somewhere. Thank you very much. We'll see you.
Oh, hey, one more thing.
Yeah.
The Canadians are officially known as Kanakistanians. Okay, so stop referring to them Canadians. They have a title that we have given them, and they are great. They are great at it. And don't worry, if they take offense, they'll just apologize to themselves. So.
Thal's going to be banned really quickly. Thanks, Thal. We'll see you later.
Bye, buddy.
We love our Canadian friends. Thank you very much. Welcome. Thal means no harm by anything you said there, whether you're French or Canadian. All right. Let's see. Please see Ruth Buck's message. I see this one. Is there another one from Ruth? Let me see what we've got. Oh, they're coming in the courtroom right now. Sorry, I'm trying to see. I will be getting a lot of HDMI to SDI adapters. I think the adapters are the way to go, so that some of my equipment that is still going to be HDMI, sort of like computers, the computer outputs, rarely you get SDI on laptops and things like that. So it's also used in ham radio, yes. Ari thinks he's doing his Saturday morning AM radio show, Cable Talk. Yes. Okay. Let's focus on trial really quickly. Apple River sentencing is happening today. I don't know who's carrying it, honestly. Because we're so close to the end of the trial here, we might, if they end early today, we might go back and see if we can watch that, because that should be fairly quick, depending on what victim impact statements are shared. Okay. Can I share something just funny, just really quickly? We've had a renter in our Airbnb for the last 2 weeks. And by a renter, I mean 3 people staying in the unit, a mom and 2 daughters. On my phone, I get notifications every time the door locks and unlocks. They have 2 vehicles, and they literally are living and have been living and coming and going 50 feet from my house. I have yet to see them once. Like I've yet to see a shadow of a person. They are the quietest, sneakiest, invisiblest people I've ever met. They're so quiet. Even when they texted me and said there was a problem, we went in and fixed it. They were gone when we went in and fixed it. And it's crazy. I have a buffer from Amber. She's going to have to do it again. I cannot find it. Can we summarize the morning for the channel or for court?
All right, welcome back, everyone. It's after lunch in 2020 CF 3014.
Cameraman's not back yet.
All right, jury's being brought up. Anything we need to talk about before the defense calls their next witness? Oh, I'm so sorry. I was looking right over top. Oh, it's a good point. We can check and see if this thing's working again.
It should be.
All right, looks like my real-time viewer is working again. All right, welcome back, everybody. It's after lunch now. We're all back.
So the judge
in
is watching the channel.
CF
That's what I heard.
3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in.
Yeah.
Justin Warren.
This morning we had Bruce Ferris. He's the Duluth model guy. He talked about abuse, all the different types of abuse in that big circle that fall under this. We had Gina Torsia. She worked for Stephanie Murray, the lawyer, and she just was one more person that basically told us that Stephanie Murphy probably wasn't telling the truth about the scheduling for what was going to come out and when the report was going to come out, things like that. It's just another second witness there. We had Vincent Vizzacaro, who's the real estate guy who said Doug wanted to buy the house or rent the house right behind Ashley's during the time. Well, the lawyer told us during the time that there was a no contact order in place, even though it was just jointly agreed to. And then we had Jason Quintel, who was he was a state's witness that came on again, this time called by the defense, and the defense was able to get him certified as an expert, which the state did not do, and they got testimony as to what his findings were about Doug, and that he was very controlling. I'm not sure if he said manipulative. There was some alpha male talk in there. His driven to keep the marriage together at all costs type discussion.
All right, y'all can sit down.
And not in a positive
everybody.
light.
As we were breaking, I saw some folks got new pads of paper, and everybody's pen is still doing okay? All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. Defense calls Justin Warren.
We started him young. We love it. We love it. Justin Warren. I thought it was Warren Justin.
So affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
I think he's an officer, right?
Oh, sir.
Thank you.
No pin.
Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir. Your Honor, with the court's permission, permission to treat as adverse.
You can go ahead and approach.
Oh, look at that. The spice. What he just asked, he said, we would like permission to treat this witness as a hostile witness, adverse witness, a hostile witness. What that means, if the judge grants this, is that he can lead. It means that this witness does not want to be here, is actively on the other side. They're at odds with each other, and he's going to try to extract information out of him, which will allow him to sort of pin him down a little bit and make him answer questions if the judge grants this. And obviously the state would not want that. they'd want him to just question and tell the truth, but he'll have to give the judge reasons as to why this is an adverse witness. Could be spicy. Could be very spicy. Wow, what a start after lunch. Somewhere there's a message from Calypson's Vixen, Amber. It's now scrolled off the screen. You'll have to send it again. I cannot find it, Amber. I've looked and looked for it. It got buried in the chat. Is this spicy bacon? What is? Oh, those spicy. That's ballerina. Okay, I thought that ballerina ballet shoes. It looked like bacon to me. You can see what's on my mind. How do they know he's hostile? Probably from a prior interaction, maybe like a deposition. Let's see if this is granted.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information at the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right. Does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Lead detective was not called by the prosecution. This is the first time we've seen him. Probably make a good call on that.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case. Would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair?
Yes, sir.
With conclusions supported by evidence?
Absolutely, yes, sir.
Yeah, not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms. Benefield?
Pretrial rule.
Just asking the question.
Overruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that?
Objection, pretrial ruling.
Sustained.
Whoa. Can't go into that.
Did you describe?
Objection, pretrial ruling.
We're cracking up. Question. Let him ask the question.
Let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from the front.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry?
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
Yeah. And it's your position today as you sit here that...
Objection, Judge. Can we approach, please?
Yeah. So what happened here, this guy, this detective, early on in the case, appears to have made an arrest affidavit which they're not allowed to go into for pretrial rulings, where he stated that the Doug was shot in the back. The only problem is he wasn't. He was shot on the right side of the chest, and it went from right to left across his chest. So I think best bet he can say he was shot in the side. Very, very defiant, this attitude. The state is making all the objections to make sure something doesn't come out in front of the jury that would make them look bad. It's not from the front though; it's the side, right? But Wyax, I know this is like it's almost semantics. It's so subtle, but the trajectory of the bullet did go from right to left across the body and from front to back. So technically, even though it's the side, it was in front of. If you were to draw a horizontal line down the body and stick your arm straight out, horizontal line, the gun when it fired was in front of that line, and they're playing that card, even though it, you can clearly see he was shot sideways. I mean, the bullet entered in his side and didn't come out the other side, I think, right? But no, there was an exit wound, but it like completely smashed his spine. It went through. I mean, it was through the side. It was. And the spine probably redirected the bullet as well. But very, very interesting and spicy argument here. There wasn't an exit wound on that one. Thal got immediate timeout with the first comment after the call. That's funny. Are you back with us, Thal? I think you are. If anyone is being shady here, it's the state, not the defense. Let's see, sideways because he was in that fighter stance. If he said from the back to make the arrest warrant look more solid, would that be falsifying? Created by EJF. We know he said that because that's what leaked out to the public. That's what we heard leading up to this trial is, well, this is going to be a spicy trial because he was shot in the back, and that's not self-defense. Apparently, I mean, it's a subtle difference, but that's not true. He wasn't shot in the back. Could have been turning. Why didn't the prosecutor not?
All right, members of the jury. We're going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back as soon as we can. Remember, don't begin deliberations, talk with anybody about the case, or do any research on the people, places, things, or legal topics you've heard anything about.
We might be getting a proffer. We might get to hear a spicy preview of what may or may not come into trial in front of the jury. We get the spice. Or someone's about to get a whooping. Yes. One of those two is about to happen.
All right, sir. We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss the questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
Okay, So our first adverse or hostile witness of the trial, or at least declared hostile witness of the trial, is out, and now we hear some legal argument.
So there's, as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the long-standing doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit.
Got to have something else.
All right, so witness. These issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pre-trial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross, or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object, because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the A#1 first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate, and based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition.
He needs to get other evidence out of this guy, or else the judge will rule this out.
I don't see
just impeachment.
Why. That is not fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield, and he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
What report is that?
That is a report that he authored a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or checked the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will, and
on that form.
No, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form. It says bias motivation, he types in none, no bias. The next block says bias target, it's blank, and the box after that says bias circumstances. That too is left blank. Would you like me to show you?
First, I don't think he filled that out.
Even if he did, I don't know which
I don't see the judge letting this go forward.
No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
Awesome event. I love that hobby.
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning at the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box, and I want to ask him if he knew who that witness was, and he's going to tell me it was Doug Benefield, and I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that, rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings. Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least 2 deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there has been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness, and the law is very clear, and I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people who are killer or murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about The statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified? That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State, anything else?
No, Judge.
Continue.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
Oh,
Well, hold on.
okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to that.
I think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
the DNA
report.
Yeah, he submitted the exemplars and he got the report back.
All right.
Curative
I don't know if
instruction.
I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah, plus it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall crime scene swab both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Ms. Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's, okay, go ahead.
My objections are not to the business record certification judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said.
There was.
I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay.
CSD
There's
Megan
not a
Dvorak
person at
testified
DNA Labs
that they
that
were
can
swabs.
say where those swabs came from. They only know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report, and the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is a DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this, and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence, and I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, Judge, I already said all those things, but it's just frustrating because all the steps to get that reported under certified business records have been skipped. And so, although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant, and you can ask him. I think if that's his supplemental report, I think it's close, but I'll let you ask him. Here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about, and aren't solely to impeach. So, all right, let's.
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So
right.
I would
So
prefer that he
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in.
Here come some more objections from the state. They're not going to like the way Mr. Taylor tries to do what the narrowed scope the judge allowed. This is frustrating because DNA evidence in this case I think is powerful. Ashley and Doug were not together at this time. They were literally moving stuff out, moving to different locations at the time. I would say that there probably shouldn't be Doug's DNA all over her wrists and forearms.
All right, sir. Did you speak with anybody about your testimony, or did anybody approach you to speak with you? Did you talk with other witnesses about their testimony, or the questions asked of them?
No, sir.
Do any research on the case? Watch it at all?
No, sir.
All right, let's go and bring the jury in.
So while they bring the jury, I will also say that this is a huge oversight from Mr. Taylor. If he saw the state wasn't going to call the DNA experts, he should have called them. If he knew the results of this, why would he not call those DNA experts? That's massive, massive failure on defense's part. And this goes to support the DNA on the wrist. That would mean that he grabbed her, basically. That's the logical assumption. That why else would his DNA be on her wrists?
Seat. Welcome back, everybody. Did you begin deliberating amongst yourselves, talk with anybody outside the jury about the case, or do any research on people, places, things, or legal topics? No. Everybody says no. You may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
Yeah, you documented it in your report, did you not?
Yes, sir.
All right, my last question.
Just looking at the state.
Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify?
Sure.
Okay.
Is that your report?
It appears to be. Yes, sir.
All right. Can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
okay,
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
Defense has to be careful not to open any doors here.
This section that says bias, isn't this for hate crimes?
Sorry.
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box. Okay. But
so this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
Correct.
Thank you.
Redirect.
Do you think it odd that you're the lead detective in this case and you weren't called
beyond
by
the
the
scope.
state?
Sustained.
Whoa.
No further, nothing further.
The judge is mad.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
do I need to stay in the building, or can I leave?
No, sir, you can go, but you need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
They have my email. He was not supposed to ask that question. He was not supposed to ask that question, and he did.
Call your next witness.
I'll try to come back to it. We call Dr. We call Michael Hay.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thanks, sir.
No, sir.
Appreciate it.
My name is Judge Ryder, presiding. Make yourself comfortable in that chair. Get about 12 to 15 inches from that microphone. You adjust up, down, left, right. There you go. And just speak in a loud, clear voice. It'll pick up everything.
Thanks, sir.
He's the first person to actually adjust the mic.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haag, H-A-A-G.
What type of work do you do, Mr. Haag?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a Bachelor's of Science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haag, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taken classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. If you can spell it.
What?
Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Tool Mark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haag, any forensic presentations of note?
I very regularly present, both at conferences as well as for organizations, on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which a certification applies to an individual, and accreditation applies to a laboratory, so those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California, and Texas, and Rhode Island, and I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I worked cases from Iraq and many other places that I lose track of.
Because he's the guy.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It could involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene, and then you move that system from one place to the next. So you can move around corners, and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005, and since then many departments have also seen the value of it, particularly with trajectories, in my opinion, and it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course, and so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that can be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines. Demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
Thank you, Manny B. Thank you so much.
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets?
Correct.
All right. And this information that was provided to you was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand, in a way, where they'd been. And this is sort of one of my main areas of interest, is the damage to projectiles, sometimes, depending on their condition when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo, or created through intense engineering by people at the companies, such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't over-penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over-penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So, for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take one of four off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable tumbling. Before it got there, this is basically a nice stable bullet entry, and that bullet was recovered there, so that's one of four. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which, as I recall, this is bullet number 11 in the crime scene images, I believe, while it looks fairly mushroomed, it does not demonstrate soft damage, and the hole going into the bedroom wall is, again, a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's two of our four bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming of the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface, and those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on down range and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is, but that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area, so we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly, so we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5 as I recall, is that it does show soft damage. It is expanded. In the images you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which, as I recall, enters on the interior left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have two things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullet's recovered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity, we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects in the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom, and we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you, with regard to sequencing, which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right, that's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body, but because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident or otherwise, if we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things. Front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects, bodies, regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because, again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those two trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor. Thank you.
This could be very powerful testimony for the defense if he can get this communicated to the jury. Talking about the way the bullets traveled and where the shooter was located when they were fired could support the story that Ashley told on the stand. Some microphone abuse going on there. Definitely is getting paid by the hour, though. That's clear. Trying to remember his password right now. Give him a minute. Fun fact, these bullets he described, the 45 caliber bullet, I believe it was a Colt 45 or a 45 ACP. Colt 45 travels at about 800 feet per second, where a 45 ACP goes between about 800 to 1,000 roughly. That's subsonic. Means it's below the speed of sound. They're very heavy rounds, and they have a lot of stopping powers, which means they transfer a lot of energy from the projectile.
What I'm showing you
into the
here
target.
is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall?
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room.
It's pretty cool technology. All built with a LiDAR scan.
Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11 maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there is an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that, and I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you can see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room, so the bottom wall as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that, so green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those 2 cones look like that. That's actually a 10 degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you To the right.
If I may, Mr.
Please,
Hagan,
yeah.
as to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent.
There's no way to tell which one was fired first.
To the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
and that's another bullet, is that correct?
Correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct. But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Okay. Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is an industry standard, and based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haig, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr. Haig.
Cross?
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body straight.
Oh, this way?
Right. Can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes. I'd have no way of, yeah, correct, yeah.
Thank you. No further questions.
Redirect?
No, sir.
Can this witness be
Turned
released?
pretty far.
Yes.
Yes.
Direct
Sir, you're
side
releasing
shot.
your subpoena. You're free to go.
Thanks, sir.
Thank you.
Okay, that was very
It's going
technical.
to take him a minute to put that away, and it's about 10 minutes after 3, so I want to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. So no deliberations, don't talk with anybody about the case, and don't do any research. All right?
Very technical testimony, probably too technical without a simplified explanation.
That'd be better than having you
hustle. Thanks, sir. Appreciate it.
I won't
All
show
right,
what he's
we'll
doing with
stay
all
in
those
recess for 10 minutes.
projectile rods, but so we're going to recess now. He did a very good description of what happens to a bullet when it's fired. He talked about when he had his hands up, showing the casing. Imagine a big hunk of lead, okay, shaped to be a in sort of a cone shape, it has a nose on it and a chunk of lead. It's in the diameter of 0.45 inches across in the bottom. That's a circle. That's the diameter of the bullet. It's a little bit smaller than half an inch across. On the top, the part that flies, towards the target, there's a dent. There's a hollow in the top, and he's explained that. That's why it's called a hollow point. The point is hollow, and the effects of when it hits tissue or liquid, as he called it, the liquid that fills that causes the pressure for it to mushroom. We call mushrooming, and it basically expands the tip of the bullet so that the front face of the bullet is larger than the 0.45. It might even double. It could be almost an inch in diameter at that point. So you've got this chunk of lead, okay, which is traveling at, depending on the firearm and the charge, it can somewhere between 760 and maybe 1,000 feet per second. Okay, so that's in 1 second. It's going across, how many football fields is that? 3 plus 1. It's a long way, but it's actually fairly slow for a bullet. A lot of bullets are supersonic. They go faster than the speed of sound. This one goes slower than the speed of sound, but it carries a lot of weight, a lot of energy with it, and it hits and it mushrooms, and it's designed to the mushrooming makes it be a bigger objects trying to pass through the liquid. It means it slows down quicker. It transfers all the energy into the target. So even though it was going that fast and it's heavy and it's a bullet, it didn't go through him. It stopped before it came out his back. But the effect was transferring a ton of energy. And now that I hear it, you guys called me out on it. I said, your feet don't go flying up in the air. With the fact that the Doug was a smaller person, with the fact that it large caliber, hollow point, 45 point blank, so there's very little muzzle velocity lost between the shooting and the target. That could explain him being off balance, especially if he was in motion already when the bullet hit him, even if he was withdrawing a little bit. That could make some sense. But big bullet, lots of force. She missed 2. She hit 2 is what I heard. No one says he was turning to walk away. The testimony was that he was turned sideways in sort of like some fighter stance. I think that's what she means when she says fighter stance. Instead of a fighter stance is not stand there straightforward. Fighters turn sideways, and you've got a leading arm and a guard arm. So that would be the fighter stance, and that would explain the trajectory. It's consistent with her story. I I think the DNA was a huge mistake for the defense. They should have got that in. I know they were all carrying boxes and things like that, but they only wanted Doug there to carry some of the heavy stuff that was in the garage. And yes, they were moving things together, but they were loading things in the truck because they're going to two different places. They're moving to two different places in Maine. Doug was going to one place, Ashley was going to another. They were going to put Ashley's, hers loaded last, so it would be offloaded first, and then he could go on to his spot. Yeah, I think that DNA would have been helpful for the jury to hear about. Let's see. I'm getting some touching messages on the burner phone. Thank you very much. Thanks to all those who are reaching out in many different ways. Really appreciate it. I will try to respond to all of them. I just have so many. I'm still in the same spot. I haven't moved. Well, not just sitting in my chair, but I'm talking about on this case. We have a believable, meaning that the words of the testimony were consistent with the evidence of the crime scene, a believable self-defense scenario. And I don't think the state has proven that it wasn't self-defense. Laura, we're looking at options. We're definitely going with an upgrade, which it may look like the exact same machine, but it has different connectors on the back. Instead of having 2 outputs, it actually has 4. That's the only other change, which allows me to send the signal to more places, which is really helpful. It would also allow me to use that when I go to courtrooms where the pool feed has multiple cameras, where I can build my own view. Say we always want to see the judge on there, we could keep the judge's face up there. We always want to see the defense or the prosecution, we could keep that up there, and I could choose what is on the screen. That would help a ton in what we're doing. That's something I've been looking forward to for a while. So it's going to be, I think I've decided not going for a massive all the way up to 4K upgrade. First of all, most courts, they don't even provide anything over a 1080p HD feed. So having a 4K switcher is just overkill. Most court streams are 720p, not even up to 1080p. So let's see. If Doug was right-handed, a fighting stance would have had his right shoulder to the rear, not to the front, and he was shot in the right side of his chest, so it doesn't make sense, right? Do we know if Doug was right-handed? Is there anyone who can tell us that? That would be interesting to see. I mean, I'm left-handed, but not that I get in many fights, but my fighting stance is left hand forward. I guess my right hand is still my dominant punching hand. I can't remember the last time I got in a fight. I think the last time I got in a fight was probably in high school. And it was a very one-sided fight. I got hit upside the head with a gun, and I threw one punch and ran. And lived to run another day. So that's the last time. Lady Laura, thank you very much for the super chat. Oh my goodness, we had a massive super chat from Nanny B as well. Thank you very much. I appreciate your generosity. Little B as well. Thank you, all of you. You guys are amazing. Will you do an autopsy on your old switchboard? Mr. Fix-It. Well, your name is Mr. Fix-It. I'm gonna open this up and see if I can find a burned out capacitor or something. Tech nowadays is so small. It's hard for me to fix it.
I'm not sure which one that was on. I think it was on.
On the
Young Mr. Galvano.
Yes.
So we might use him as a exhibit.
1080p is between 1400 and 1800. 4K is 3800. That's a big difference. But 4K, it's not what we use.
Who's this last witness going to be?
This is Dr. Emma Liu, Your Honor, LEW.
Well, don't bring her in yet. I was just asking. While we're on the subject, how long do you think she's going to be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes.
All right. So you know she's going to say,
Yes.
presumably what your question is going to be.
Yes.
I only ask because that will take us, assuming we start in the next 5 or 10 minutes, 5 minutes, to 4:20, and I guess at that point probably let the jury go for the evening. Well, you can announce you rest. We can let the jury go for the evening. You guys can say if you're going to call any rebuttal or not, but then maybe one pass through the jury instructions. I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to bring up is that we didn't bring it up during the question, but I think that Your Honor had clearly told Mr. Taylor at the bench what he was allowed to ask Detective Warren, and that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And as to the don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have, that Mr. O'Keefe continues to practice law in this courtroom. But I just think that at this point, the state is asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Okay. I'm not going to take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you for letting me be heard.
Absolutely. All right, looks like we've got everybody back. Is Dr. Liu ready? State, are you ready?
Yes, Judge. Thank you.
Wow. Sanctions. They want sanctions.
We'll bring them in. Do you need the?
I don't think so, Judge.
I don't think they're going to get any meaningful sanctions on this. Because what do? Do you punish the defendant because the lawyer screwed up? How do you sanction at this point? He did ask a question the judge told him not to ask. She objected immediately. He sort of finished the question.
All right, y'all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case, or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Liu.
Dr. Emma
Raise your right hand this morning.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon, Doctor. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone, just so we get a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Your Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Lew. Let's take a moment. Let me just run you through your undergraduate education. Where did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Lew?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Lew, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Line's security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
I want to teach a course on a cruise line. Sounds great.
Taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Lew, what is an autopsy?
An autopsy is the examination of a dead body.
It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot. Not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right 5th rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through-and-through gunshot wound, or what we call a perforating gunshot wound, that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me,
as your story's making sense,
using the easel, show you a picture and have you explain to the ladies and gentlemen of the jury. You mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay. So how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up. Dr. Liu, here is a pointer that will help you. Good.
State, feel free to reposition as you need so you can see what's going on.
Thank you.
With court's permission,
Yes,
I
ma'am, you
ask
can
Dr.
step down.
Liu to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, with this one. All right, would you tell us what that represents, Dr. Liu?
This is the graze or superficial gunshot wound on the outside of the right upper arm. I know there's a
Yes, a rod.
point, a rod on the use.
We have
Might be really helpful to see this. Oh, thank you.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is
Clearly,
a little
you can
bit more
see
rounded,
here.
and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. You see this V-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back. Going from front to back and upward. And because it's on this part of the arm, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
So the one up right here, that would have been consistent with the arm out in front of him and getting shot right there. This is all checking the boxes for the story.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
Let me see if I can tell.
Not too much. It's me. Probably the right orientation.
Dr. Liu, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Liu, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20-some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Liu. Give me just a moment, Your Honor.
Wow. I don't know why the state didn't object again, but she clearly speculated on the answer that she gave. The judge said, I will only allow it if she won't speculate. She did.
Dr. Liu, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by
He's just rubbing it in.
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
So now Mr. O'Keefe, who is 3 times the man that Doug ever was, size-wise.
Step down, Your Honor?
Yes, ma'am. Please do.
Hey, Dr. Liu, step down.
Is now going to... Oh, no. This is somebody else. It's the law clerk. It's not Mr. O'Keefe. We got the handsome guy that's sitting in front of Jules. I wanted to see Mr. O'Keefe up there.
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Liu. You just can't say what Ms. Benefield told you.
Okay.
Just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
She messed this up. There's no way for her. Okay, there's no test in the world that will show you which bullet was fired first. Okay, it's very hard. So when she says the first gunshot wound would have been here, this is a lot of speculation. This is, unless you have an outside force, say like if somebody was shot on the roof, they were shot 3 times, they're standing on the roof, they hit once, clean through the shoulder. They fall down and start sliding off the roof. They get shot again. And it goes through their arm and into the roof. That might be easier to say, but which one were they shot through the shoulder and into the roof or to the arm into the roof? It's very, very difficult to say what she was just about to testify to, and I don't think he's going to get it. I think they're going to shut it down.
Dr. Liu, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm raised gunshot wound was the first shot.
Are you able to say why? What independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection. That was not.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Liu, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
The right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
She says to the law clerk,
Judge, I'm confused as to what we're
this is
demonstrating.
only going to hurt for a little bit.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand or reposition yourself.
Now, the
You need a banana peel on the
was on the right side.
thumbnail.
Okay. The entrance was on the right side of the back of the cab, and the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be
We need a shot of this.
from getting shot while he's on the ground, with the gun being in this position. So it's going in here and coming out here.
Okay. So this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right. Thank you very much. Thank you, Will. I have one last question for you, Dr. Liu. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or a crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Liu. I have no further questions, Your Honor.
Okay, that's powerful. It supports Ashley's accounting of the events. All the injuries do.
I just want to ask you about the leg wound for a moment. You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay. So there are other positions that maybe could have produced that wound path?
Yes.
Okay. The one that you are describing is just one that is consistent with it?
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly, yes.
Possibly. So if he is walking towards someone, would he fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay. All right. And you spoke about the abraded contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head would be struck on something, because the contusion is a bruise, which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of a braided contusion on the head?
Needs to say no here.
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
Correct.
One.
Okay. The EMTs are not going to drag him and smack his head into the
Dr.
wall.
Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
I think
Do you
his
have any
case is
questions
over.
on that?
No.
All right, can this
think it's
witness
over.
be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much.
I've seen EMTs grab a guy who was thinking he had a broken back and just grab him by his hands and his feet, lift him up.
We have this one issue left.
Okay. All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back as soon as we can.
We got to say, like her or don't like her, I think Ashley and the testimony that has been brought in is consistent with her story, and it introduces reasonable doubt. And I cannot see a conviction in this case.
Okay, you all can have a seat. The jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Baby.
Thank you.
Yeah.
Yes, sir.
Our legal system is set up with the whole idea that it's better that a guilty person goes free than an innocent person goes to jail. And I know some of you might be looking at this saying that's what's happening. We've got a guilty person who's getting away with murder. But the elements are here for the jury to find reasonable doubt. We have a claim of self-defense, a story of self-defense that is matched on every front, even evidence they have not heard. The DNA evidence being on the wrist, that would also go to this. I mean, there's another explanation. But the fact that there are two explanations that are plausible, that is the definition of reasonable doubt. And I don't think the jury can convict here. Yeah, that's just my opinion, Mary. I agree, and that's right. It's perfectly okay to have a different opinion on this. I cannot make a judgment call on whether or not she was abused or not, whether she's telling the truth. I can't. I just know that in Florida, the burden rests on the state to prove guilt, and there is this alternating theory which matches all the evidence, which is possible. It doesn't have aliens came down and did this and that. There's nothing that takes a stretch of the imagination to say barring our feelings about Ashley, take that out of the way. There's nothing that makes it a stretch of the imagination to say what she said happened. It's very logical and plausible. And I think that's the problem for the prosecution. I'm just saying the burden shifts to the state. Self-defense is an affirmative offense, meaning you have the burden to present it, and she has presented her self-defense claim. It does shift back to the state for that. Maybe tomorrow when we get into verdict watch, I'd love to hear from some people who have different opinions. Help me understand the alternate viewpoint. Selena, I would agree that this has been a performance for her, but I can't say for sure that this performance was a lie. It might have been. If she's telling the truth, she can perform and make herself look in a certain way, and if she's lying, she could perform and make herself look in the same way. I can't tell the difference. I can't tell that she seems to be performing there. This last bit of evidence that the defense wants to get in would be the DNA evidence. And they have some case law supporting them being allowed to bring it in. The judge is reviewing that now. What do you guys think about the state objecting to Mr. O'Keefe telling Mr. Taylor what question to ask, saying he's practicing law from the bench? Marianne, I really appreciate the opinions being shared that are different than my own. That's how I get smarter and how I learn things. If I only listened to myself talk, first of all, it'd be terribly boring, and I'd be wrong like 90% of the time. I'm not sure if the judge is reviewing the DNA report or the case law now.
All right.
Arguments.
Go ahead, sir. I've had a chance to review shorter.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was collected then went
She said she's
to
not
DNA
objecting to
labs.
chain of custody,
And
but this is her
that's what you
objection.
have to lay the proper foundation. And just, this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that they're confusing.
Sure. In rebuttal?
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her the court should recall, consult your notes, Your Honor, Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. Chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or a report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, Forensic DNA Analyst. It lists a number of items . 14 different items that were apparently sent to DNA Labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile.
Oh. John Sant is the neighbor she ran to for help.
And it gives,
afterwards,
based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons.
Judge, I would have to read that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and 3 unknown persons than if it originated from Ashley Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons.
So very little
DNA profiles of additional
John
contributors
Sant.
to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why
seriously,
the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab, and the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue. So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the 4th DCA, it says so in the very next paragraph, the reason the 4th DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403. For a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says, and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said 2 sentences. Yeah, these 2 sentences that are highlighted.
Correct.
But that's only one of the 2 sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would,
allow the whole thing in. He's perplexed by this.
So, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these 2 sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes,
as a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Hold on. You're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those 2 sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. Is this in here, or does this go in here?
Yeah, no, that I believe is in there.
No, it goes in.
This comes back.
It goes in. Judge is just fanning himself with the pages.
Oh, I'm sorry, Your Honor, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right. Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay. So, unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence, in this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
All right, thank you. Do you want that right after the first page?
You can put it right on top, Your Honor.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
so I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right. Well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect, it was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
Mm-hmm. So do you have a...
We'll rest.
Okay. Let me bring the jury in.
Apparently,
I will...
apparently not allowed.
We can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Yes, sir.
Just so you know also, we had submitted, the court may recall, requested copies of the proposed homicide charge, and we had submitted our version to you that we thought would be appropriate, and I did not save a copy of it, so I wonder if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
We're going to start a poll.
back, everybody. Y'all can have a seat. All right, did anybody do deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor. Ms. Benefield has no further witnesses, and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries, or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out. And we'll have the deputies come down and get you as soon as we're ready and bring you up and get started.
Yes, sir.
All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening.
All right, we are done with the jury for the day. We're now going to go to the jury instructions. If she gets convicted, I think she might have grounds for an appeal on ineffective counsel for failure to call the witnesses for the DNA. That's pretty rough.
All right, I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find.
Clip.
Yeah, it was. Yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May, and I just wanted to include it in case we need
So you got the new one.
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy so we could go through it.
And you get an extra copy for.
Yes.
All right. So 5 minutes. I'll be right back down as soon as I check.
Thank you.
All right, judge is running a little field trip upstairs to get some paperwork. Ooh. Is there an earthquake in Barstow, California right now? All right. Let's see. The poll, we're going to close the poll out. I think we've got a good mix, here. We've got, looks like 68% say not guilty, 31% say guilty. As always, YouTube takes a percent for themselves. We were 1 vote short of 600. There is a police chase live somewhere. I'm just not seeing it yet. I think I think there's a very good chance that she's not convicted here, not guilty. You can see reckless endangerment, but not murder. I don't see premeditation in the evidence. Premeditation would be involved for murder 1. She's only up for murder 2, where premeditation is not a factor they have to prove. Virginia, no, he did not allow the DNA in. And one thing, I really like this judge, but it's he's been consistent throughout the trial. When he gives the lawyers an opportunity to argue an issue or a motion in front of him or in a hearing, they each get their turn. He listens and gives them all the time, lets them say what they need to say, and then when it's his turn to rule, their input is done. And so Mr. Taylor tries to add things. He's like, whoa, why are you talking? Why are you talking, Mr. Taylor? You had your turn. Now I'm making a ruling. This is my turn. Mr. Taylor left things out. He forgot to mention things. Sometimes he spoke inartfully, and he's trying to correct it. And the judge is like, I'm sorry. I have to make a ruling based on the argument that I've received.
Call from
Jules.
Jules, hello. How are you doing?
Hey, I'm fine. Is everything okay with you?
Yeah, my wife's sister lost her baby. She was pregnant, and they knew that the baby had health challenges, and just found out that they lost him.
I'm so very sorry. Please express
I
my
will.
condolences.
I apologize for pushing you off the phone. I appreciate you letting me dump you unceremoniously
family
there.
First. No, family first. You know that.
Yeah.
Family first.
What was court like for this afternoon?
Actually, it was very interesting. First time I could say that I saw a lot of interest with the jurors. As far as Detective Warren is concerned, that was like a nothing burger. It wasn't, his testimony, in my opinion, wasn't fruitful for either side, and quite honestly, the jury appeared to not be interested in him.
Mm-hmm.
But Michael Hay was a whole different story. Yeah. Everybody, the jurors were really paying attention. They were taking notes, especially the two men were taking notes. It seemed like they were really, really interested in him. And were you aware, I only found this out after he finished testifying during the break, were you aware that his father had something to do with the Rust trial?
Yes, this was funny because when his dad testified in the Rust trial, the whole time every answer would be like, my son and I did this. My son and I, we worked together. I work with my son, and then we have the son get on the stand, and every answer is like, well, my dad and I. There's so much a team. It was so funny to see.
But I did not make the connection until after he was done testifying, and then we were all talking, a group of us with him, and there is a group of teenagers that are sitting in the courtroom, and one of them asked if she could have a moment with him, and at first he was like, I can't talk about this case, and the grown-up man said, no, it's not about this case, it's about what you do. She wants to get into that. And he was ever so graceful.
Yeah.
And he spoke with this young lady, and that's when I found out who he was, that he was the son of the guy from the Rush trial, and I was like, holy moly.
It is funny. Like father, like son, I guess, is what we have here. He was a little bit long-winded in his explanation, but he's very smart, and I liked the visualization. I liked that he pulled that up. That's something the state did. The states had this. This is their evidence. Their crime scene techs gathered this image, but he's the one that presented it. And for that to come across from the defense to explain things, I think that was helpful for the defense.
I think so too. And then Dr. Lee Lou, whatever Emma, her name is, the ME, they from what I observed, they liked her as well, and it was very dramatic when they did the thing with
the law clerk.
Yes, and when I tell you when the judge said if you need to stand up, you can. Well, I expected them to stand up and stay where they were at. They did not. They all moved. In fact, two of them, I was afraid was going to get caught on camera because they actually came a little bit out of the jury box, and but they were like, that is the first time I saw that much I don't know if enthusiasm is the right word to use, but like, yeah, they were interested. Yeah.
And we actually saw basically none of that because the camera angle we have, the prosecutor stood up and blocked that. We just got a shot of her hair briefly. So all that happened on the ground. We just heard an explanation. Tell us, could you see?
Yes, I could see. It was, well, when they were doing the stand-up part, for like the
arm?
the graze,
yeah,
for the graze and the chest. Obviously, he was standing, but when he was down on the floor, I mean, he was down there, and his legs were raised, but not where they were straight up in the air. But how do I explain this? Picture yourself kneeling, but you were on your back. Like, how your legs would be if you were kneeling on the floor?
Yeah. So his legs are bent up over him.
Yes. Yes. Yeah.
Interesting.
It was very interesting.
If you put him on the floor when that happens, that makes more sense because the way it sounds they're describing it. Let me use Gumby. I've got Gumby in my studio here, So the way they're describing it, they say he got shot here, and then he flips up in the air and then gets shot in the back of the leg. But really, it could have been he got shot and goes down, and the legs sort of just continue their motion and curl up around him down on the ground, and then he gets shot in the back of the leg, which makes a little more sense.
Right. Which she said that the shot, that went in to the front and went sideways to the back, hit the spinal cord, and it would cause definitely for him to fall and for him to not be able to move. So that makes sense that his legs would go up in the air. I found her credible, and I think so did the jury.
Yeah. I can't demonstrate this very well with Gumby. But so the shot goes here, he flips, and his legs are bent like that as he falls backwards, and the second shot goes through the back of the leg in an upward trajectory. So it hits down lower and goes upwards towards the knee.
Right. So that's how it was demonstrated on him with the sticks, because she was using the sticks as showing the direction of the bullet and all of that. Yeah. So that was like really, really interesting. Now here's where I think the prosecutor tripped up when she did the cross-examination. Now remember the actual Emmy. He said that he hit his head on the tile. That's where the bruise, abrasion at the back of his head occurred. What was your take when she's trying to intimate, is it possible that when they were dragging him out, he sustained the thing on the back of his head at that time?
I think what they should have done there has been very clear about the direction of the injury on the back of his head. If the back of his head, if it was like horizontal, like right here, I'll show you. If it goes like across from like, I think of ear to ear, somewhere on your head, across the back, and he met a tile there, then that would have been very helpful to describe that at the time. Because if he's being dragged backwards by his hands out the door and, hits a door jamb, that's going to be vertical, right? It just doesn't, it wouldn't add up, but they didn't get into that at all. And I think they probably could have.
But then that was a missed opportunity on the prosecutor when the Emmy testified. But now to throw that out there during this witness, that didn't sit well with me. But anyway, it is what it is.
Jules, as always, we love having your insight into the courtroom. Thank you very much for sharing with us.
You're welcome. Have a good evening. Again, I'm very, very sorry, Scott. Please extend that.
I appreciate that. We sure will. Thank you.
And everybody have a safe evening. Bye-bye.
Bye-bye. Thanks to Jules for being our eyes in the courtroom. We are going to be back in just a moment in court. We still have jury instructions to go over. Let's see. I like playing this. I'm trying so hard not to squeeze the little squeaker toy in the middle of Gumby here. I did it that one time, and everyone's like, dogs went nuts. It's like Tourette's. I grab it and I go to squeeze, and I'm fighting the urge to squeeze this.
Call from Angela.
Hello, Angela. How are you doing?
I'm doing good. How are you?
I'm doing well. I'm doing really well.
So I have a confession right off the bat, and that is that I have not watched a lot of trials since Friday after lunch.
Mm-hmm.
I watched something like after lunch today, and I blame Olympics for that. But seems like I came into the right in the right place. There's something that I wanted to come in on Friday and to talk, and that has something to do with Ashley and her background. Everyone knows that I work in science and I love to do experiments, but what people do not know is that I do have music background as well. I was music major in high school.
I didn't know
and
that.
I have had and I had a lot of performances on stage, and so I'm coming in from that perspective onto the Ashley. I caught glimpses of her cross and all of her direct. We are. I mean, whatever branch of arts we are, either theater or dance, or if we are musicians, we do have some sort of a tell, or we want to put on a show. But I did not see that naturally.
We're back from court.
I did not see that.
Didn't see that?
Yeah.
I gave it to them, and this is
I've got to let you go. We're back in court. Thank you so much, Angela.
I'll come back
This
later
is
when
the state's
with
proposed.
what I'm talking
If you have
Okay.
a copy of ours, you can toss it because I made corrections.
Right.
Okay.
And as we get started again, I was able to find the jury instructions the defense had handed up to me in the past, and I've had my judicial assistant run a copy and gave them back to the defense. And I think you had also given me this case, Gonzalez v. State.
The name alone?
Well, let me. It looks like the handwriting that's been on a couple of your other documents, and so let me give it back to you, and it might jog your memory as to why you gave it to me.
It's not my handwriting.
Is it Mr. O'Keefe's?
Oh, we'll wait. I didn't look over.
Yeah, so actually, I remember. I think Gonzalez was our consideration and debate about whether or not we could get a charge of self-defense based exclusively on the 9/11 tape. We're a long way away.
We're missing someone.
All right. Do we just toss that? Or you keep it? Okay, sure.
We're missing one key player here.
trying to see if I have the right page.
If they move. Sorry, Madam Clerk. I was trying to hold it back.
It's okay. I just wanted to see if I have the right packet.
Well, let me show you, let me show you what I gave to the judge.
Right here.
Yeah.
It didn't look like that. I
think it is.
think it might be missing some of the highlights.
Okay.
You got to address subject matter jurisdiction? So it looks like you have to update the version.
So court has finally ended and they figured out how to turn off the microphone that was on the paper. Like literally, defense rests. And we just got the mic, the paper mic turned off. Day 5. Day 5,
All right,
they fixed the audio.
Benefield is back. So we're going to take a look at jury instructions now. So make sure that
I knew it was too good to last. We're back. We're back with the noise. Shannon, have no fear. Papers are here.
Yep.
All right, so defense, do you have a copy of the state's proposed jury instructions?
Yes, sir.
And state, do you have a copy of the defendant's proposed?
I believe we do.
And then I have mine that I did separately. If we could, I'd like to start with the state's version, and then when we get to an instruction defense that you have your own ideas or thoughts on, we'll see how we need to modify them or mesh them. So, Ms. Benefield, these jury instructions, as I've mentioned before, if I haven't, I will mention now, are very, very important. Too often, I think, people think of jury instructions kind of as an afterthought. But whenever we started this case, I had mentioned to the jury, and I say this several times, they listen to the testimony and receive evidence. They listen to the argument of counsel, and they listen to the instructions on the law by me. So this is 1/3 of what they are supposed to look at and consider. So the way that it works is obviously the defense has prepared some proposed jury instructions. I've got some that I've worked on, and the state has theirs. The reason I'm working from the states is that's just how we've always done it, at least in this circuit. It's generally the state prepares jury instructions. We kind of work off those. So as we go through, some of the things that I've mentioned in the past or have talked about or will talk about become much more clear when you really see the jury instructions and this is what the law is. So, Mr. Taylor, the way I do it is I'm going to, again, work from the state's version, which you have, and I'm going to call out the number. I won't read the whole thing, and just let me know in this first pass as we go through, do you have any objections, additions, corrections, or deletions to the standards? Then we can, after we go through that first pass, then we can get into some specifics.
Okay, and would that include omissions?
Yes, absolutely.
All right.
So, for example, the first one is 3.1, Introduction to Final Instructions. Any objection to that one?
No.
All right, so that's good. Looks standard. 3.2, Statement of the Charge. Any objection, correction, addition, deletions to that one?
No.
All right, looks fine. Now, 7.1, Introduction to Homicide. That is one of the ones that you provided to me.
They'll be tomorrow. Closing arguments tomorrow. Jury deliberation starts
And
tomorrow
I think
after
it's
that.
just the standard.
Might be some
Mr.
rebuttal
Taylor,
too.
is it just the standard that you provided, or is there a difference?
No, I provided in my packet that I provided the court with, I provided the standard.
Okay. So there's no, I just wanted to see if there was a disagreement, because ours should be the standard as well.
So if you look at the...
Mine was not edited.
Understand? No, I see that. Yes, right. You just gave me, the actual printout that I look at from the Florida Supreme Court website. But so as you look at 7.1 as proposed by the state, do you have any objections to it?
Judge, the problem that I'm having with this is I haven't had time really to review this, so I can give the court an answer off the top of my head, but I don't know how I'm supposed to check for a misprint or a word that's been omitted.
I see what you're saying. This is why I call this my first pass. It's really a 30,000-foot overview. I mean, it's not uncommon. Right at the end, what you'll find is I have this thing about Oxford commas, and
is he for them
I
or
think they
against
need
them?
to be used.
Yes.
I
Yes.
don't understand not using them.
He's my man.
But so there's quite a few places where we're adding commas and so forth. Please don't worry about those kind of details. I'm just talking in general. And this is one, quite frankly, we can skip if you prefer. Just you want more time to take a look at it. That's absolutely fine.
No, with that explanation, then no objection.
And I can tell you, it's standard other than we added the charge and the name.
But if you see any typos or anything...
Simone is just a different breed of athlete. She is absolutely incredible.
All right, the next one is 7.4, murder in the second degree.
And the yellow were things I didn't know if they would be applicable, so just so we make sure we didn't.
We're going to hear if there are lesser included
I think as I look at this overall,
in the jury instructions.
it looks like you've got just the standard in there. It looks okay. The issue is going to be if you all want that highlighted portion, if you want the sudden provocation. And I don't need a final answer now. It's highlighted, so you'll be able to let us know if you want that or don't want that.
Okay.
It's in there for now. Possession of a firearm and discharge causing death, 3.3D should just be the standard 1020 life instruction. All right, 3.3D looks right to me. And in fact, the one that I have from the defense, page 7 of 28, except for typeface, looks exactly the same. 3.4 lessers. So this is page 8 of 28 on the defense.
I believe that that's the right statement as to the introduction to lesser.
You don't have to stand. If you want to, that's fine, but...
However, it's our position there should not be any lesser.
Right, so Are you prepared to make that argument now, or do you want to wait? It's up to you.
I think I can probably make it now, perhaps with the court giving me consideration that if I think of something overnight, I might be able to supplement.
That's fine.
So we would cite the court to the Roberts decision, State of Florida versus Geraldo Roberts at 694 Southern 2nd 825, second DCA case. It was a charge of attempted second-degree murder, aggravated assault, discharge of firearm from a vehicle, and carrying a concealed firearm. Reversed for the trial court's failure to give an instruction on attempted manslaughter and on definitions of justifiable and excusable homicide. But there is the statement made as follows. The trial court must instruct the jury completely on all necessarily included offenses, regardless of whether the facts of the case support the instruction. In this case, the trial court was required to give an instruction on attempted manslaughter and on the definitions of justifiable, excusable homicide. The trial court's failure to give the instructions is fundamental error and can be considered on appeal even though defense counsel did not object. And then they cite Rinaldi versus State, also a second DCA decision, 614 Southern 2nd 1197. And parenthetical for what Rinaldi stands for is conviction for second-degree murder reversed because the trial court's failure to include definition of justifiable homicide as part of manslaughter instruction, even though defendant failed to object. They say this then at that point: the only exception to this rule is if defense counsel affirmatively agrees to the omission or alteration of the instruction. So, on behalf of Ashley Benefield, we request no lesser included offenses. We think this is an all or none. She either is guilty of second-degree murder or she's not guilty.
State, do you want to be heard?
Just that we disagree. It's a category 1 lesser, and the state's asking to include it.
Okay. For right now, I'm going to tentatively say leave it in. But again, you want to look at some stuff? No, I'm familiar with the case, though. Yes, sir. I'm very aware of those. You wanted some more time to look and see if you could find anything. So that's fine.
Come up with anything else.
Leave it in for now. And as I look at manslaughter, it does look correct.
It appears the manslaughter instruction appears correct to me. However, I'm just not sure about the applicability of the various subsections at this point.
All right, and then 3.3a, the next page is the aggravation for the. I'm sorry, did you say give you a minute?
Yeah.
Oh, yeah, of course.
Yeah, no, I think it's.
Oh, all right. Yeah, 3.3a looks like the standard. All right. Justifiable use of deadly force.
Excuse the boldness, Judge. I just don't think we got that far without fixing it.
Right. I'm looking across 3 different pages here. Yes. here's, are you on 3.6F?
Yes.
All right, so here's going to become the first issue. Right about the middle of the page, Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent, of course we know there's two. I'm sure you want A, imminent death or great bodily harm to herself.
Yeah.
Are you also asking for an instruction on the forcible felony?
Absolutely.
And I saw that towards the end of your paperwork. And it looks like you're asking for, you see that state towards the back of their packet? It looks like you're asking for burglary, felony bat, ag bat, ag assault, false imprisonment, that looks like all of them.
Burglary.
Yes. Yeah, I started with that one. I actually went from back to front. So,
oh, okay.
Burglary, felony bat, ag assault, and false imprisonment.
I believe that's correct.
There you go. There are the charges. False imprisonment, though?
Sure. I'm maybe misunderstanding. Is counsel asking for all of those felonies to be included?
I think that's your starting point.
Yes.
Their definitions of false. I think he's asking for an explanation of what it means.
Let's start off easy and ask, are there any of those forcible felonies that you agree with the court instructing the jury?
Before we get there, Judge, on the standard that I gave you, can you read the sentence right before this paragraph? And it says the law on justifiable use of deadly force is as follows. And then it says, give if the defendant is relying on 776.0122 or 776.0312, but not relying on 776.0131. So it seems like now you're supposed to pick, because it is repetitive. Because that same language is in each section.
All right, 776.0122. It appears, I would say, that the defense is relying on 776.012, subsection 2. That's the self-defensive person.
It's the second part of that sentence. It says, but not relying on 776.013. And I believe they are relying on 776.013.
All right, that's protection in the home.
I'm sorry, I just caught this. Can somebody tell me why? I'm gonna turn this off just for a minute. Why is this Mr. Kelly? Was Judge Fink over Mr. Kelly? Hang on. Do you guys see this?
Sí.
Yes.
What is your date of birth? Septiembre 3 de 1990.
Did somebody see? Is Mr. Kelly back in court? I thought this was dismissed with prejudice.
Have you consumed anything that could cause you to be confused this afternoon?
I'm just looking. Is that
You're
him?
on probation for facilitation.
I can't tell, but that looks like him. That was. Let me see what court that is. Is that even in the right court, or I'm just really confused? It's a Monday, so anything can happen. It's Judge Fink.
All right, do you see what the state's saying?
Yes, I do. This is a rather unique factual situation. I'm not sure at this point I have an answer for the court.
All right. I'll outline it, and let me just say that having served on many rules committees in the past and currently serving on a rule committee, it is yeoman's work what they do. And I can only imagine how many hours went into the criminal jury instruction committee putting 3.6F and 3.6G together. And I know sometimes we will fuss, or I will fuss, at the complicated nature of these jury instructions, but they really are good, and I appreciate the work of the committee. So to put it simply, on the standard jury instruction, from the part of give if defendant is relying on 776012 sub 2 or 776031 sub 2, but is not relying on 776013.1. Because 776013.1, as we know, gives even greater protections, or establishes and explains the Castle Doctrine, from which Stand Your Ground expanded that Castle Doctrine out into other places. But I think what the jury instructions are saying in interpreting the case law is that if the defendant is relying in part on that home protection, 776013 subsection 1, a person who is in a dwelling or residence in which the person has a right to be, has no duty to retreat, and has the right to stand her ground and use or threaten to use, and then A, non-deadly, and B, deadly. And the reason that that distinction is made in these jury instructions is because if you're not, you automatically get those protections in the home, right? But 776012 is more of the general use or threatened use of force in defense of a person. And in that situation, the additional information that because it's not in the residence, the jury has to be instructed on the duty to retreat, or the non-duty to retreat, and a right to stand your ground if the person using or threatening to use deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Obviously, because 776013 is in the home, which Ms. Benefield was, would lend itself to the argument being made by the state that we would not have the first part of the standard, but we would skip down to give if defendant is relying on 776013 subsection 1, self-defense in the home, because it has all the same things, except now you're in your home, so the jury does not have to consider that you, whether or not you're engaged in criminal activity, or whether or not you're in a place where you have a right to be, because you are.
Judge, what is 0312?
0132?
No, 7760312. It says, give it.
That's defensive property.
Property.
Yeah.
I remember putting the instructions together, but I didn't remember what the substance was.
So I think, and of course, it's imminent death or great bodily harm to herself, or the imminent commission of the forcible felonies, and we still have to, once we determine which forcible felonies we're going to give. So
okay,
that's just me putting that on the record for future reference, posterity's sake. All right. The next one is,
So are we taking that first part out?
well, I'm just putting
Okay.
what my interpretation is of these jury instructions and why I think ultimately we're going to give the second one, 776013 sub 1, as opposed to 776012 2.
Yes.
Glad it's clear to one person.
I don't think we've had any arguments about necessarily 782.02. Essentially, 782.02 is essentially a restatement of what we would cover under 776.013 sub 1. I think it's kind of duplicative, but I'm sure each side will have their own arguments.
And Judge, I think just for timing, I think we're going to be closing early tomorrow.
Okay.
I don't know that we're going to have a lot of time to, you know what I mean?
I understand.
Okay.
I was going to ask the court, you already announced that we could close in the afternoon, so we'd be able to clean this up.
I'll just say that I was kind of leaning that way, that whatever rebuttal you want to do, cut them loose, and then whatever, we still got a into the road JOA, if you want to make one.
Yeah.
And then I figure that's it. Now we know what evidence is in. We can put the final touches on everything. You'll have had this evening and tomorrow morning to look at these issues and get them finalized. Then you guys make the copies for us. I usually ask the state to make all the copies with and without verdict forms and so forth.
I just played a clip of Courtroom 4, Judge Fink's Courtroom.
But if we send them away
Somebody
early,
looks like him.
we can have them back at 1 o'clock, 12:30, whatever we want, to give you guys time to do your closings.
I don't anticipate rebuttal's going to be very long.
How much time do you think you're going to want to ask for closing?
First and second together,
Yes, total.
probably an hour and a half to be safe.
Mr. Taylor?
I'll take that, but I doubt that I'll use that.
Yeah, I don't know that I will either.
So I'm glad you asked about timing. Yeah, I think you're right. That's probably what it's looking like. We'll be here first thing in the morning, any rebuttal, then rest, and then I'll let them go and tell them to be back, whatever makes sense, 12:30, 1 o'clock. Then we'll come back, then we'll stay, get all the jury instructions done. When they come back, we'll go.
Do we want to find out what the rebuttal is so we can make any argument if we have it before the jury comes in?
Yes, absolutely. Yeah, but let's cover that in the morning.
Okay.
All right, so we were on the 782.02. I'll let you guys argue, but I think that that might be duplicative of what the instruction that's already going to be given from 776.013 sub 1.
Judgment of acquittal is a request where you ask the judge to basically decide the case
next paragraph
in favor of the defense.
deciding, that certainly needs to be in there.
Without the jury doing anything. There are 2 points where you can do a JOA. Once is right after the state rests, once after all the evidence has come in, and then after that you can make a request in some states for a judgment notwithstanding verdict. After the jury comes back with a conviction, you can ask the judge to overturn it.
Oh, that's where we left off. Were there any of those forcible felonies that you're prepared to agree with right now? That way it'll limit what I have to hear argument on.
And I just wanted to make sure I got them all. They were burglary, aggravated assault, aggravated battery,
Felony bat
felony bat.
and false imprisonment.
I thought I heard false imprisonment. I don't think I have that one, but okay.
Yeah, it should be in my packet, Suzanne.
It might be, but I just couldn't find it. And Judge, to be honest with you, I've never had more than one felony read, so I don't quite know how to respond.
Yeah.
Typically, the defense will focus in on what they say the crime is and move forward from there, but.
Well, you guys both know, it's only the elements, right? The crime of burglary is, the crime of felony battery, just the elements.
Well, we would need for this case in the burglary instruction to them that a remaining in burglary is the equivalent. Remaining in improperly.
Understood.
And Judge, I think remaining in improperly with the intent to commit a crime kind of covers a lot of the other crimes. So
I don't know if we can agree, because I don't think that I don't think that there is evidence that has come in of felony battery, aggravated assault, and then false imprisonment. I'd have to go back and read, but that one we may have evidence of that. And then of the burglary, I'm not sure, because I don't know what the evidence came in to commit a crime therein, stayed to commit a crime therein, but I need to think through it. But I can say that I would almost guarantee we'll be objecting to ag assault, ag bat, and felony battery.
All right, so be prepared for that. I'm not saying you need to commit to it now. I want you both to be able to go back to your offices this evening. This is why I do this big overview. That way you guys can go back. You've already heard a little bit of each other's thoughts. Nobody's locked in. But then you can go back tomorrow loaded for bear.
I'm trying to figure out if
presumption of fear.
If this is something they say that she was experiencing or something they say she did, because there's no testimony about her getting falsely imprisoning Doug.
Yeah, the 776013 sub 2.
I don't think this comes in because it's forcible entry into a dwelling, and I don't think there's any evidence of unlawful and forcible entry into a dwelling.
Burglary comes in because she told him to leave and he wouldn't leave. That qualifies staying somewhere where you're not supposed to be.
Yeah, I think I'm inclined to agree with that.
I think so. So that would be out.
And I think thereby the next section will be out too.
Yeah, which is the presumption does not apply if. So it's both ways. The presumption applies if and does not apply if. I think that can all be out.
Now he's talking about just reading the definition of what these crimes are. He's not saying these are the charges against you. He's saying in the jury instructions, I'm going to define these crimes for you because they're probably going to be mentioned in the arguments.
Too, because it's all talking about by force.
And just so I'm sure that we're on the same page, that's the part that starts 776.0134.
Yes, ma'am.
Okay, thank you.
I don't think these are particularly the charges.
So the next part about 776041, there's certainly, it's only the one charge. There's no other forcible felonies.
And I think we can take vehicle out right above that too, for safety's sake. But yes, I don't think any of this next part comes in.
Right, there's been, and I don't expect any evidence that the defendant was attempting to committing or escaping after the commission of some other forcible felony.
Correct.
And so I think that's all out.
Judge rips the paper, scratches it out.
State the next one regarding aggressor and whenever the defendant, there's some evidence where the defendant was the main or initial aggressor and then the force comes back when the defendant would be justified in using force when they were the aggressor.
I don't think there's any evidence.
I don't either.
I had already crossed it out, sorry.
Okay, is that all right? I don't recall any evidence that Ms. Benefield was the initial or main aggressor.
It's down at the bottom of the page, it says aggressor, and then it says Gibbs v. State right above it.
Yes, okay.
All right, so that will be out. The next part is absolutely in.
Yes, I
'cause
think
that's
the next two parts are.
the thrust of the defense.
Yes.
So prior threats is in. However, the reputation, I don't think there was any testimony regarding reputation of the victim.
Agreed.
So the next two would come out.
Yeah.
And then the physical abilities is in all.
I'm sorry?
The last one's in everything. It's reading all cases, the physical abilities.
Yeah, physical abilities is in.
Absolutely.
And I will fix these tonight and probably email them tonight or tomorrow once they're all
If you would, that would be great. I'd appreciate that. All right, so see, this is why I do this kind of general overview, so at least we can figure out where the touch points are for disagreement. All right, that's 3.6F. We're not giving 3.6G, right?
Sorry.
Use of non-deadly force. Everybody agrees?
Yes, yes.
Okay.
Sorry, I got confused.
No, I just want to make sure because there's some cases out there that talk about both of them. You give one, you give the other.
I think it says now in the new standard, it said at the bottom, unless evidence establishes force or threat was deadly and non-deadly as a matter of law, and then it goes on and says the discharge of a firearm, whether accidental or not, has been deemed to be deadly force.
I'm still going to belt and suspenders it and make sure everybody's agreeing we're not giving 3.6G.
I understand.
All right. All right, so now this should be pretty quick the rest of the way. 3.7, plea of not guilty, reasonable doubt.
Yep.
All right. 3.9, weighing the evidence. Now, on this one, Ms. Benefield, of course, Mr. Taylor's has the copy right there. The 10 issues regarding credibility and factors for the jury to consider, 1 through 5 are given in virtually every case I've ever been involved in. We do 1 through 5. 6 through 10, however, really depend on the facts of the case and whether there's factual support for giving it. So 6, any evidence of 6?
No, the state doesn't believe so.
All right, 6 is out. 7, pressure or threat. State?
I don't think so, Judge.
Defense, any argument you want to make about pressure or threat?
I don't believe so, Judge.
Let me explain
Right,
something.
7 is out.
I'm going to mute their
8,
audio here for a
certainly
little bit.
8 stays in because there's been some impeachment. So 8 becomes 6.
Okay, I'm muting this audio just for a second. Or actually, let me just turn it way down, okay?
Conviction, impeachment.
Okay, I'll keep it right there. They're reading definitions of different crimes. And these are crimes that the defense is saying could have occurred, or there's evidence they occurred against the defendant, justifying her in using deadly self-defense force, deadly force in self-defense. So the judge will define those crimes for the jury. These are not, the false imprisonment is not against her. She's saying that she was trying to leave and Doug grabbed her arm and wouldn't let her go, said, "Where the blank are you going?" and held her by the arm, pulled her back. That is false imprisonment, and that is a crime that she can legally use deadly force for to prevent.
Then I stop, and then I will explain the verdict form to the jury and go over it and explain how it works. That way you don't have to use your valuable closing time explaining how the jury verdict form works. You can just get right into it.
Okay.
When we come back, I'll touch on 3.10.
If you leave it out, it's a
And that
crime.
looks
It's a crime
fine.
of omission.
3.11 cautionary. That looks fine. 3.12. All right, so 3.12, when then we come back and I give the final instructions, I of course read 3.12, but down at the bottom where it says it is as follows, I just tell the jury, I previously explained the jury form. All right, 3.13, submitting the case to the jury. Did you already take out the thing about questions?
Yeah, that's actually on. I think that's on rules for deliberation. I took it out. Is that what we took it from? But yes, I took it out.
Yeah, no, it's on 3.13.
Oh, okay. I'm sorry.
There's in 3.13. It's not in the state's version because they already took it out. There's the one paragraph in the standard that talks about questions that were asked during the trial by the jury but weren't answered, and I removed that because I don't allow jury questions. And then at the bottom, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. These exhibits will be sent into the jury room with you when you begin to deliberate. However, and it's up to you, we can craft this in here, but I usually ad lib at that point. For example, if it's a child pornography case, you got to come out and view it. If it's a CPT tape, you have to request to view it. In this situation, I would say we're going to send the firearm back with you. Is there live ammunition?
There's no live ammunition. We did not bring it.
Oh, okay. I thought there was.
Correct me if I'm wrong, clerk, but I believe it's all casings and expelled bullets.
So the testimony was that live rounds were found. There was a live round in the chamber and live rounds in the magazine, yes. But those live rounds have not been introduced into evidence.
Correct. They were packaged separately by crime scene, and we did not bring them for that reason.
All right. So with that said, everything goes back, unless you guys say something different.
No, I just wanted to wait because it was a firearm, but I think it should be A, not B, and I'll just make it one paragraph.
Yeah. So usually if there's a firearm and magazines and live ammo, it's one or the other. Either you can have the firearm and the magazine, or you can have the live ammo, but I don't have that problem here. And then in closing, let me remind you, now the verdict form, aren't we going to need some special interrogatories?
Oh, yes. I'm sorry.
I was going to say, mine is just...
It is. And I was looking at it thinking, wow, this is really short. Yes, sir. I'll fix it tonight, and then we'll have to look at it tomorrow. But
the one that we end up usually using, as you would imagine, the defendant is guilty of murder in the second degree as charged. And then underneath that are the special interrogatories for the 1020 life. Then you'll have B, the defendant is guilty of manslaughter, a lesser included offense, and there's the one interrogatory regarding actual possession of a firearm, and then C, the defendant is not guilty. So that's what it should look like.
So one lesser included.
But obviously you've tried cases all over, so if there's that's the standard we use here in the 12th here in Manatee. If there's some other format that you used before you think is better, certainly willing to listen.
I like putting not guilty first on the list.
All right. Thank you very much for giving me that extra half hour and going over the jury instructions so we understand who's where. And if there's nothing else...
If there's nothing
Richardson, else... Do you want to do that tonight, or do you want to do that in the morning?
Oh, man. We're still going. Quick Richardson hearing.
Judge, and I'm going to show them an exhibit I intend to introduce tomorrow, and they may have another. This did not become relevant until rebuttal. I mean, it's for rebuttal. It didn't become relevant until after the testimony.
Okay, so we have the two photographs for Richardson hearing.
Yes, sir.
And the rebuttal. A apparently the state is going to recall Eva Benefield. The court may recall it has been holding in abeyance my motion to strike her as a rebuttal witness.
Judge, and I can maybe simplify. I intend to ask her a question about this picture that I'm holding up. I intend to ask her a question about the pictures that were introduced by the defense of the gym pictures, just to ask her if she's familiar with those and when they were taken. And I also intend to ask her if her father was right or left-handed. And that's all I intend to ask.
Right or left-handed?
So I don't know that sitting in would have tainted any of those answers.
This has to do with the fighting pose.
All right, can I see the picture you're talking about? Is there an issue? What's that one marked? What number?
105. 105.
Was this one disclosed?
Yeah.
You got 105 or no?
Yeah, that's the photograph.
Right.
Just now because it was not relevant to rebuttal.
That's what I'm asking.
Yeah, it was not a discovery.
Okay, there we go. So we're going to include states 103, which we referred to as the modeling photo. 104 as the mugshot. And 105, I'm just going to call that one the boat picture or boat photo because they're on a boat.
What's he going on about?
Yes, sir.
Or about?
What do you want to take up first?
How about the Richardson violation?
Yes. So they were never provided at all in discovery. Not only were they not provided, but let's be clear, because if I've learned nothing else, I've learned this. They weren't provided in a dump at any time, so we were completely unaware of those photographs.
Can I just ask, is that argument for all three of the photographs?
Yes, we, to our knowledge, were never provided with that photograph either.
No, the reason I'm asking is because the mugshot photo was entered in the stand your ground, so I don't think that was.
Well, hold on. Let me keep some semblance of order, even though of the late hour. So, right.
I thought the mugshot's in already.
That's one of the two that we're talking about.
Yeah. So here's the three photos we're talking about for this Richardson hearing. States 103 is what we've been referring to as the modeling photo. Go ahead and pull them out. I'm so sorry, Madam Clerk. She asked if we wanted them, and I said no, and now it's probably better we do. That's 103. 104, we've been referring to that as mugshot, and 105 we're now referring to as the boat picture. And the mugshot, my notes are 103 and 104 were not admitted.
Correct, and that was just an oversight. They were published and we spoke about them, I just didn't say the words.
Correct. All right, so I have them up here if you want to review them.
And
I have them here if you want to review them.
Would like to say the mugshot was disclosed in discovery. I can find the discovery page, the date stamp page if you need me to, but it was disclosed in discovery.
You can take those with you if you want.
Yeah, there was a companion photograph with this that they sought to introduce that we never got either.
No, it was that one.
Was this?
It was that one.
Yeah, just those two.
Okay, I could have sworn there were two. Okay. So, you want me to address the wedding photograph? The modeling photograph?
Yeah, all three of them. Yes, sir. You know, go through the Richardson factors with me on all three.
Okay. So, we believe it to be, I have no evidence to present to the court that it was intentional. We believe it to be inadvertent. However, the prejudice is substantial. And given the late hour of the introduction, we've never been advised, so we've had no opportunity to meet it. And the trial is over.
All right, State.
Judge, speaking about them individually, and I apologize, I don't know which picture the mugshot is, but that was disclosed in discovery, so there is no violation. What we call modeling photo, I believe that's actually from the ballet pictures. That picture did not become relevant until the defense's case, and the defendant testified, and also Dr. Russell testified about seeing edema and swelling, and it became very important to show before this incident and after this incident what she looked like. And I don't know how that can be of any prejudice because it's a picture of the defendant. It's not like she didn't know it existed. And I don't know how the defense would have prepared differently. So I don't think it's a violation, first of all, because it didn't become relevant, and we introduced it at the time when it became relevant. And then as to the boat picture, I have the same argument that that did not become relevant until the defense's case. So therefore, we produced it as soon as it became relevant or very close thereafter. So it was no violation to begin with.
All right. Tell me about what is the relevance of the State's 105?
The relevance is that the defense put in pictures of the victim at the gym to show that he was all muscle bound and, you know, to try and show. Those pictures were taken in 2018.
Which pictures?
The muscle bound pictures that the defense put in.
Okay.
That picture was taken a month before he died. He did not look like those pictures that the defense entered in 2018.
How do you know he's got a shirt on? I mean, if you look at his arm, the vein is bulging on his bicep.
To the weight, not the admissibility, Judge.
What kind of watch is that? Is that a Rolex?
When did you become aware of State's 105?
Last night.
All right. Final thoughts to the objecting party.
Mr. Taylor, this is actually your turn to get up and talk. She's like, hey, the judge asked you to give your final thoughts. So now is when you need to get up and do that.
Put in about Mr. Benefield, how he was built, were in May of 2020, not 18.
I don't recall that evidence coming in. The date of them?
I'm just informing the court. The representation was that they were taken in 2018, and we're telling the court they were taken in May of 2020.
All right. And just so you all know, and what I'm saying to that is, as someone who hasn't been involved in this case as long as you guys have been, and don't know all the details of it, I don't recall that testimony when the photographs were put in. I don't think the date of them was established.
I'm just correcting the representation that they were May of 2018. I'm telling the court they were from May of 2020.
All right, thank you both very much. So in a Richardson hearing, obviously we talked about it before. The issue is whether it's willful or inadvertent, trivial or substantial, and what prejudice is being suffered by the non-offending party. That is the one that's opposing the introduction.
Oh, she's mad.
Or didn't have the information.
Do you see that?
Or exhibit. I'm going to start with 104. Actually, all three of these have a different analysis, unfortunately. And I'll just mean that because that means I have to go through it 3 different times as opposed to giving you just one simple analysis for all 3.
Judge, I'm sorry.
Yes.
I just want to make sure. We haven't yet discussed the Richardson analysis for the modeling photo, have we?
Yes.
Oh, then I do want to add something.
Oh, please, yes.
Yeah. The prejudice to us. So the court may recall in my testimony, I specifically pointed out the drooping eyelid and the space between the brow and the eyelid. And the prejudice to us is going to be substantial because they're going to now introduce this picture taken at a completely different time with makeup and everything else. And they're going to argue that she looked like that here, therefore you can't believe what they said about the photo that was introduced, that was taken by the sheriff and staged on that day. And that's going to be substantial prejudice. And one other thing, Your Honor, about the photo with the daughter and the father. You know, there's a sympathy factor about calling the daughter to begin with, which was why we objected. So now this is a second bite of the apple. And if they want the photograph really just to show that Doug, by some crystal ball, they know he's not built like that underneath his shirt, then they should splice the photograph and remove Eva from the photograph if it's just to show Doug.
I'm not sure if they're going to do that.
right, thank you both very much. So 104 is an easy call. 104 is the mugshot, and that has been disclosed. It was used at the Stand Your Ground hearing, and in one of the more recent pretrial hearings, this in particular was one of the issues we talked about, and I was on my way to ruling that the state could not use it in its case in chief, but could use it in rebuttal, and that's where then one of the two of you jumped up and said that was your intent anyway, was to use it during rebuttal. So I don't find that there was a Richardson violation. That's been disclosed. It was discussed multiple times as this case is going on, so there is no prejudice there. As for 103 being the modeling photo, when did you get this picture?
It was I think it was the night. It was either the night before her, at lunch. It was at lunch during her testimony.
I found it on the internet while we were eating lunch and then tried to enter it. So.
I don't think it's coming in.
And tell me your prejudice for this again.
I had specifically pointed out when we put Ms. Benefield on the stand where the slap was beside the left side of her face, and asked her about whether her eyelid was, it reflected a droopy eyelid and swelling in the space from the eyelid to the eyebrow. And the state is now going to use that photograph to argue that that wasn't the case at all. There was no swelling, no damage, because here, take a look at the eye in this photograph. It's exactly the same.
Judge, I think that's...
And then they might just add, can I put this on the record ex parte? I don't want to help the state in their closing argument.
Okay.
Ex parte, come talk to the judge, tell him something. This is the second time he's requested an ex parte mid-trial. Ashley can hear. This is something he wants to tell the judge, this is why it's prejudicial, but I don't want to tell the other side or else they will use it. It's like telling them what cards you have when you're playing poker. You don't want them to know. So one of the rare times we have just the one side up talking to the judge. Normally it's both. Thank you, KK. Love the dog picture as well. Profile picture.
Surprisingly, I find this to be a much closer call. It's difficult to say that it was willfully held by the state because they didn't get it until the lunch. Well, direct happened in the morning, then we took a lunch break, and then cross happened in the afternoon. Let me ask you this, State, and I hate to do this because I know I'm usually very specific about I want to hear all argument and then I rule. When you procured State 103, you come back over, did you show it to the defense?
I did.
Prior to beginning your cross?
I did. Both of those pictures.
I'm sorry?
I showed them both of them.
Both of them?
And Judge, I just want to also add, the defense saying that they would not have spoken about the swelling on the side of her face, that same argument goes for the mugshot. And they had every reason to know that I was going to try and put the mugshot in after she put it into evidence. So I don't know that that argument necessarily holds, because they were on notice that I was going to make this argument, just maybe not with that picture.
All right, I do want to give you the final shot, though, since you're the objecting party. Anything else?
Well, the mugshot is 6 weeks later, and you can't discern from the mugshot what you can discern from this photograph that we are discussing now.
Ashley's adamantly interjecting ideas for her lawyer.
Again, the composition also of the photograph is different. This one is heavily with makeup.
I think that goes to the weight, not the admissibility. All right, so the state didn't have this until that day. They showed it to the defense prior to beginning their cross-examination.
It's not going to be a violation.
The purpose is not, I characterize it more as a rebuttal piece of evidence based upon the defendant's claim about the slap and so forth. And I understand why the state wants to use this, because they have 104 is coming in, which is the booking photo. But I look back at my notes just to see about 103. And on 103, when it was authenticated by the defendant, it was a modeling photo, and it was taken before she even met Doug, are my notes. So I have to find that there's some sort of prejudice and that the defense would have changed or been significantly different to meet that prejudice. And I just can't say that I find that, because the issue of the swelling above the left eye has been an issue since the stand your ground. And all 103 does is show the anatomical structure above the left eye at a time before she even met Doug. So I can't find that there's a Richardson violation. So 103, over the defendant's objection, is admitted. The predicate was laid. For 105, this is, again, it's difficult to say that it was willful because the state just obtained it yesterday or the day before. When's the first time you disclosed it? Today?
Today.
Oh, I'm sorry, that's not 104. I apologize, Madam Clerk. 104, I found there was no Richardson. It is received.
Tomorrow.
No, I'll just do it now.
Okay.
103 and 104 received. 105. I don't think, first, so I can't find that it was willful. Trivial or substantial, I think it's certainly the relative size and physical abilities between the defendant and the victim is an issue. And the defendant has the photographs, whether they're from 2018 or 2020, the photographs of Mr. Benefield working out, where he is in, to put it mildly, extraordinary shape for a man his age. So I don't think it's unreasonable for the state to want to put in a photo of what he looked like a month before his death. I think it goes to the weight, not the admissibility of the photograph. With the argument between the two parties, defense can argue, yeah, but this shirt doesn't show him ripped. These other ones show him with his shirt off. They can make that argument. The state can argue that he wasn't as ripped and strong as he was in those photographs. But I don't disagree, and I've done this before where editing the photograph, for the fact of having his daughter in, and it's going to come out that there was a month before a month before his death. They're both smiling on a boat, having a good time. I think there's some, not the prejudice as preparation prejudice, but no, this would need to be.
I didn't get to respond to that. Can I just respond?
Yeah, go ahead.
Judge, I think the relative size of the victim to his 15-year-old daughter is very important in that picture, because they know, the jury knows that his daughter was only 15 at the time that this picture was taken, and I think it helps gauge his size.
But the jury only knows how big the daughter is now.
Very shortly before, and if you crop the daughter out, there's nothing to gauge.
All right, I appreciate that. Overruled.
Denied. So they're coming in. All the pictures are coming in. Just only half of one of them.
She was 19 at that photo.
Either way.
He doesn't care. Judge rips out the scissors. He splits the picture himself.
Now, the question for you is, do you want this in?
I can crop it and print it out on a big piece of paper.
It's already been done.
He's like, I'm using this one. I've already cropped it right here. Judge gets all crafty.
Oh, were you asking if I wanted the other half?
Yeah, do you want the other half?
Whips out the Ginger shears or whatever.
Your question was.
Oh,
I'll take the other half.
You literally split the baby. You're right.
In the record, because you're saying you want it in. Do you want it in?
Oh, we can just put it in the record then. Thank you.
Everyone's
Can I call that one
laughing
105A?
A, yeah.
That's going to be State's Exhibit 105A. It is not entered. So the only ruling I've made at this point is
epic.
105 is admissible as I have cropped it.
Okay.
But we still have the issue of you want to get it in through Eva,
Yes.
Benefield,
Yes.
He's like,
and you're objecting her being recalled. So we still got to get that issue.
he's like, I've got scissors for this very purpose.
All right.
Objector is being recalled on two bases. One, sympathy factor, especially balanced against the probative value of this photograph, which is anybody's guess because he's got a shirt on. And two, based upon the hearing that we had.
Did you do any additional research on
our social media? I did.
I made the ruling about the interview, right, that happened in the hallway?
Yeah.
All right. You had started to bring up some other matters, and I don't know if anything ever happened with that. No?
Yeah, I left it alone, I think, because she said she took the posts down.
Took them down. All right. All right, be heard on whether Eva Benefield, now, the rule of sequestration was applied.
Yes.
She was not released from her subpoena,
Correct.
but she was allowed back in the courtroom pursuant to Marcy's law.
Yes.
As next of kin.
Yes.
All right.
And I think the entire reason for the rule of sequestration is to provide fairness. So witnesses can't hear what the other witnesses are going to say before they testify, and where it may taint their testimony. I represented to the court like 4 questions I will have for her, and I don't think that any of those would have changed based on anything that she would have heard in the courtroom anyway. And even that being said, Marcy's law has shown that her right to be in the courtroom is more important than those types of issues anyway. So I'm not really understanding the defense's argument about her coming back in, and there are issues that are relevant to the state's case that the state wants to ask her. So I don't understand the sympathy argument.
All right, final thoughts, sir.
I think the sympathy argument is pretty obvious. And they already put her up there one time. So now we're going to put her back up there a second time. Marcy's law allows her in the courtroom. It doesn't allow her in the witness stand.
There's a better argument to be made there, and you should have researched your social media and had a little better argument there.
All right, thank you both very much. I made the findings the other day regarding what I understood to be about the brief interview that was given in the hallway. I believe there was an admonishment, and she was allowed to remain in the courtroom, although I will say she was kind of in and out. I don't find that it's overly sympathetic to recall her as a rebuttal witness, to authenticate a photograph. You said something about the gym photos?
Right. She was going to talk about the gym photos.
How so?
When they were taken.
All right. And then right or left-handed?
Yes.
That doesn't sound like anything that would necessarily pull at the heartstrings. I will say this, obviously on that boat photo, it doesn't need to be, was that the last time you went on a boat with your dad and, you missed those times? It needs to be, when was this photo taken? And then you can make your arguments however you want to interpret it during closing. Because that could be overly sympathetic to kind of dredge up those sorts of emotions.
Understood.
And then right or left hand, I don't see anything that's overly sympathetic or I'm in my head I'm doing a 403 analysis. So I think the probative value is not substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading of the jury. And I don't find it to be needless presentation of cumulative evidence. So you may recall her for those limited purposes.
And Judge, if I could just see the picture where you cut, I'm cropping the picture of the digital copy. So that's exactly what I have. Yeah.
It's been a heck of a day for sure. It's been a doozy.
All right. If that's everything we can handle tonight, you all are free to go, and we'll get started tomorrow morning.
Phil's definitely going to grab that scissor soon, I'm sure. It's just crazy.
Yes, yeah, 8:45.
All right. And we're done. All right. Wow. What a day. Ashley's not happy. I know Mr. Taylor said he picked up a cold. I think it's probably doing a number on him right now, which is terrible. Because if he's still in this state tomorrow, he's not thinking as clearly as he did before. And even that was, he's struggled at times. So Ashley's not happy with him. Had to tell him a bunch of things. His arguments have been weak. When he's had an opportunity to push the narrative with the judge and sort of explain something in more detail, he's just let it rest. He's just it's like he's taking it easy when he should be sprinting to the finish line on this. The pictures came in. That's a big win for the state. They wanted those. I think on cross-examination, even though the defense fought hard against them, they'll be able to mitigate some of the damage. Obviously, with the picture that was taken 6 weeks after, it's not going to show, theoretically, you would expect it not to show the damage from a slap over that time frame. But wow. Apple River sentencing, it's scheduled for the 31st. Melanie, I thought it was scheduled for the 31st. I'm showing that's when the date they've got scheduled for that. We were looking at that. There were some good witnesses today. Let me just recap what we had today. Let's see, day 5. We had Bruce Ferris, who is the Duluth model guy. That was great. We had a lot of that. We also had Gina Torsha, worked for Stephanie Murphy, showed that Stephanie Murphy possibly did commit perjury on the stand regarding the schedule for the release of the report. We had Vincent Vizzacaro. He was the real estate guy. Says that Doug was looking to buy or rent the house immediately behind Ashley during the same time period that they had a restraining order against each other. a mutual restraining order, judge issued. Dr. Jason Quintel back on the stand. This was a state's witness that the defense called back, and during their testimony, this was the weirdest thing, because they questioned him, and they almost got all the way done questioning him, and then after objection, they wanted his opinions. He wasn't an expert witness. He hadn't been for the state. He hadn't been for the defense. Then at the end of his testimony, they qualify him as an expert witness in this area, and then he's got his opinions in, which were very harmful to the state's argument. And just it was crazy. Let's see, what else do we have? Detective Justin Warren was the lead detective. The state never called the lead detective in their case. Defense called him. Most of the questions they wanted were to impeach him. That really got cut short, and they never got to carry that through. Michael Haig, very long-winded. He's the bullet expert. Did a good job. Apparently, the jury showed a lot of interest in what he had to say. So that's going to be interesting. He did show the laser scan of the crime scene, which was nice to get a view of that. And then last we had Dr. Emma Liu, who's a medical doctor in Florida, medical examiner. Did we have anyone after Dr. Liu? Can somebody tell me, was there anyone else? I don't think we had anyone else. And then the defense rests. I think that's all. All right, so with that, tomorrow what we're going to do, we're going to pick up, I don't know what the schedule is as far as if we're going to argue more things in the morning. The jury's probably going to be their first thing for instructions. Then we're going to argue more things, get things lined up. There's going to be some rebuttal. There's going to be that's going to be spicy because you're going to have Eva there. We're going to see if the state holds to the limits that the judge put on them, or if they try to push it like Mr. Taylor has throughout trial. We're also going to then have closing arguments, jury instructions, and then we go into we'll be in verdict watch tomorrow is where we're going to be. So deliberations are going to begin. So that's everything. That's everything that happened. Day six of the trial. Tomorrow's going to be spicy. This case is spicy. I want to see how the defense and the state wrap this up in their closing arguments, where they really put things together and try to spell it out for the jury. It is crucial. It is crucial for Ashley's defense that Mr. Taylor gets this right. If he has an off day, this could be very detrimental for her. Braxton, thank you very much. Hope you had a great day at work. Hope you enjoyed your first day at work. Thank you, my friend. I appreciate you. TYO Toys, you've got to go back and look for the judge whipping out the scissors, cutting up the evidence, the photos. Just amazing. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning about 8:30, 8:45-ish. We'll see you all here. First person in chat, as always, gets awarded the internet. That could be you. Make sure you click the subscribe button, ring the bell so you're notified as soon as we go live, and then just be the first person to talk in chat, and you will be the winner. About to catch a whooping. I'm about to catch a whooping, I think. Let's see, why is my camera 4 not working? There we go. Okay. This thing's just acting up. I can't wait to get this replaced. Thank you so much. You guys, we will see you tomorrow. Thank you so much. I don't know if we need to toss to anybody. Is there somebody else who's up? Do a quick check here. Get everything in order. Media, picture. There we go. I think Peter Tragos is doing something tonight, maybe. I can't see anything yet. We'll see. We'll see you guys in the morning. Bye-bye.
Are we going to address subject matter jurisdiction?